Wednesday, 5 justices had unanimously agreed that the 5 grounds on which the PDP and its candidate Atiku Abubakar challenged the electoral victory of President Buhari was flawed. Let's get more perspective now. With me in the studio here is constitutional lawyer Kennedy Osunwa. Thank you very much for joining me at this time on the news. Looking at all that transpired yesterday at the Court of Appeal in Abuja during the delivery of the judgment, the initial issue about the president's qualification to contest, do you think all that drama now or controversy has been rested finally now?
Of course, the court of appeal and the justices of the Court of Appeal, in its wisdom, evaluated all the evidence that the counsel or the solicitors to the PDP in the presidential election, and of course, one would see that the president and the commander-in-chief of the Armed Forces, Federal Republic of Nigeria, has been vindicated by that judgment. So the issue of the president's certificate has come to rest. And therefore, every other evidence tendered by the opposition to the ruling APC, goes to show that the justices of the Court of Appeal, in their wisdom, evaluated the evidence and also came to conclusion that the petition of the opposition has not been proved beyond reasonable doubt. In the sense that if you look at Section 9 of the Electoral Act, that stipulates that there will continually be updating of the National Voters Register, and that 60 days to the election, such continuous updating and the registration of voters will stop. For instance, if there is an evidence by the opposition to show that that 60 days ultimatum was not adhered to, then it becomes an evidence against the ruling party. For instance, because remember, the judiciary represented by the justices of the Court of Appeal in this case are embodied and charged to interpret the law. It is the law they interpret. It is not any other thing. The
duty is not to create laws.
They cannot make laws.
As what the judge said.
They cannot make laws.
Yesterday.
They are to interpret the law. And once the issue of evidence is not in law, for instance, you say you are using that the INEC used server to collect election.
In fact, that was even one of the many issues where the justices insisted that the onus had since shifted to the Atiku camp, and he failed them in providing sufficient evidence.
because okay, one of the counsel to the opposition now argued that that section, that's omnibus section, has been reviewed in 2015. But there, as of today, our law, there is no such law. So it cannot, speculation cannot work for the opposition. So, and you cannot expect the justices of the Court of Appeal in their wisdom to base the judgment, because this judgment is crucial for Nigeria, for the international community, and for the common man.
But quickly, another way again is that hasn't Atiku also opened up a kind of worms for himself now in resorting to what the justices called improper evidence in trying to establish that there indeed was a server?
Of course, that is, yes, that was their burden of proof, which they failed to discharge. Because if you say there is a national server where the results are being embedded, then the onus of proof is on the opposition, not on the ruling party. So, and their failure to prove is very fatal to their case. And that is why the tribunal, in their wisdom, had to dismiss their petition. Because you cannot add something on nothing and expect it to stand. It will amount to total collapse.
All right.
And again, there is one issue again that is burning that you have to look at. The issue of the allegation that the ruling party made use of security agents to either buy votes or to rig the election. They have made this allegation, but there's an issue of law.
All right.
Why did you not join the security officers as party
pertinent
to
questions,
the suit?
Pertinent questions
So
that you re-echo.
Yes.
I'm afraid we've run out of time, Kennedy Osunwa.
Thank you very
much for your contributions on the news at this time.